Straight ahead on Law and Crime Daily, the jury begins to deliberate the fate of Kyle Rittenhouse.
When you've agreed upon your verdict, have it signed and dated by the presiding juror as to each count, and all of you return with the verdict to the court.
We're now on verdict watch for the accused Kenosha shooter and the death of Ahmaud Arbery.
Is there anything law enforcement or EMS could have done to save his life at the scene?
I don't think so, no.
The medical examiner takes the stand in the racially charged case. Plus, a former Trump aide turns himself in to the FBI. How long could Steve Bannon be behind bars for criminal contempt of Congress? And later, controversial broadcaster Alex Jones found guilty by default in a defamation lawsuit. Why this means a victory for the families of Sandy Hook School shooting victims. Law and Crime Daily, covering court cases from coast to coast. And welcome, everybody, to Law and Crime Daily. I'm Brian Ross, in for Brian Buckmeyer, who's in Georgia, covering the trial of the men accused of killing Ahmaud Arbery. Joining me here in New York is co-host Terry Austin. And Terry, we begin with a verdict watch in Wisconsin, where a jury is deliberating the fate of Kyle Rittenhouse. 18-year-old Rittenhouse faces 5 charges, including reckless murder and attempted murder in connection with the August 25, 2020 shooting in Kenosha, Wisconsin. 2 men, Joseph Rosenbaum and Anthony Huber, died as a result of the shootings. Gage Grosskreutz was shot and wounded but survived. Rittenhouse's team argues the defendant was acting in self-defense that night. On Monday, a set of 12 jurors began deliberation inside the Kenosha County Courthouse. That's where Law and Crime's Anjanette Levy joins us now. Anjanette?
Brian, the day started with that final jury of 7 women and 5 men being determined. Those alternate jurors were selected, and we want to show you a little bit of how that process unfolded. Now, the numbers used to identify those jurors were placed in a tumbler, and Kyle Rittenhouse reached in and pulled out 6 numbers. That determined which jurors would be the alternates, and they remained at the courthouse in case they were needed. The jurors asked for extra copies of the jury instructions. They will have to decide whether Kyle Rittenhouse acted in self-defense or committed crimes when he shot and killed Joseph Rosenbaum and Anthony Huber and wounded Gage Grosskreutz. Judge Bruce Schrader gave the jury a final instruction after closing arguments.
You will disregard the claims or opinions of any other person or news media or social networking site. You will pay no heed to the opinions of anyone, even the President of the United States or the President before him.
And you don't hear references to the President and the former President of the United States in murder trials very often. Now, outside of the courthouse here in Kenosha County, about 50 people have gathered. There are supporters of Kyle Rittenhouse along with protesters, Black Lives Matter protesters. Among them is the uncle of Jacob Blake. He is the man who was shot by police in August of 2020 here in Kenosha, and it sparked the unrest where Kyle Rittenhouse shot 3 people.
This is about right and wrong. This isn't about the Second Amendment. This is a murder case. Little Jake's our hero, baby, just like Anthony and JoJo are. His mind is just always up. His spirit is always up. If his body ever catches back up to him, it's going to be a hell of a miracle.
Now, as I mentioned, there were also supporters of Kyle Rittenhouse here. Among them, the McCluskeys. You may recall they are the couple from Missouri who pointed their guns at protesters outside of their home in the summer of 2020. They were charged and later pleaded guilty to a misdemeanor charge, and they were later pardoned by the governor of Missouri.
We think this is a political prosecution. We think we were politically persecuted, and we're standing up for the rights of others.
Now, Mark and Patricia McCluskey say they've actually not met Kyle Rittenhouse, and they have not been in the courthouse. And I should mention that Mark McCluskey is running for Senate, U.S. Senator from Missouri. Brian?
Okay, thanks, Anjanette. Let's bring in now co-host Terry Austin and criminal defense attorney Roger Foley. Roger, a large part of this case has to do with self-defense and whether Mr. Rittenhouse can use that defense if he, in fact, provoked the confrontation, as the prosecution argues. How does that sort out for you, Roger?
Well, that's the question. That's what the prosecution led to towards the end of the case. I think the case wasn't going very well for them, and they realized that if they came up with the argument that if Rittenhouse provoked the argument, then self-defense would not be a claim that he'd be able to use in this case. So that's the question. Will the jury believe that he provoked this incident or initiated this incident, or was it self-defense where he was trying to run away?
Right. And Terry, the jury is already asking for clarification on some important legal standards. What's the significance of that?
I think it's very significant, Brian. They asked for the first 6 pages of the jury instructions, and we know they were long and convoluted. They wanted to understand the definition of self-defense, provocation, and they specifically wanted to know what the charges were as it related to Rosenbaum. I think we're going to get a split verdict here overall. I think as far as Rosenbaum is concerned, they're going to believe that self-defense. But as far as some of the others, I'm not so sure. I think recklessness, as far as McGinnis is concerned, either way on Huber and Gage and all of these, if it's split, there is significant jail time. So I think that's what's going to happen.
Right. And Anjanette, the Rittenhouse family is there. What are you hearing from them?
I spoke with Dave Hancock. He has been serving as the spokesperson for the Rittenhouse family, and he feels, good about the case. They believe this should be an acquittal on all counts. They believe Kyle acted in self-defense, and they are feeling pretty good about things and hopeful right now.
Okay, thanks to all of you. Still ahead on Law and Crime Daily, a one-time top Trump advisor surrenders to the FBI on criminal contempt of Congress charges. But first, the trial of the men accused of killing Ahmaud Arbery. Law and Crime's Brian Buckmeyer is in Georgia with the trial's newest developments.
It was the video that shocked the nation. An unarmed black jogger, 25-year-old Ahmaud Arbery, gunned down in broad daylight. The 3 men charged will now stand trial. For live gavel-to-gavel coverage of the trial, subscribe to Law and Crime on YouTubeTV today.
Welcome back to Law and Crime Daily. Return now to Georgia, where the state has rested its case in the trial of the 3 men accused of killing Ahmaud Arbery. Father and son Gregory and Travis McMichael and William Roddy Bryan face several charges in the death of Arbery, including malice murder, felony murder, and aggravated assault. In February 2020, Gregory and Travis McMichael tailed Arbery in their pickup truck as he went for a jog. Travis McMichael eventually shot Arbery, claiming self-defense. Bryan followed along in his own pickup truck and recorded the incident in a now infamous viral video. At the time of the shooting, Arbery was unarmed and jogging near his Brunswick, Georgia home. All 3 defendants face life in prison if convicted. Our own Brian Buckmeyer has been covering the trial from Glynn County, Georgia, and that's where he joins us now with the latest. Brian?
Yes, Brian Ross. Day 8 of the trial for the death of Ahmaud Arbery against the McMichaels and Bryan began with more testimony about the investigation into the case and some medical testimony from a pathologist. Officer Richard Dial of the GBI testified, giving more insight to the events through drone video of the routes taken both by William Bryan and Ahmaud Arbery, based on the testimony or the evidence collected from William Bryan. Medical examiner Edmund Donahue, testifying in the trial for the death of Ahmaud Arbery, gave the jury graphic photos of Ahmaud Arbery's body after his death. We also heard that Ahmaud's arms were 23 and 26 inches in length from the armpits to the hand, and based on the wounds, a muzzle to target estimation was 3 to 4 feet, but after reviewing the Bryan's video, he estimates that the distance from the target to muzzle was 3 to 20 inches, showing that Ahmaud Arbery was close to grabbing the gun, but was shot earlier than that. Donahue also showed us injuries of the wrist and torso and speculated that the angle could show that the shot came at him from a distance close by, first striking his wrist, then his center of mass. Donahue ultimately said the injuries could have 2 interpretations.
It was my opinion that the shot to the center of the chest and the grazing gunshot wound to the wrist occurred at the same time, meaning that the hand was in front of the chest and was struck first, and then it entered the body. It was my opinion that the second shot was a complete miss and did not enter any part of the body, and that the third shot involved the left chest and axilla.
They happened at the same time. Would that be consistent with someone pushing a shotgun away from them?
It could be, yes.
Is it also consistent with someone maybe grabbing the shotgun?
It could be, yes.
Let's bring back co-host Terry Austin and Roger Foley. Roger, the prosecution introduced, as Brian just told us, a number of graphic photos. What's the thinking about that? And is there a danger it could have a backlash with the jury?
I don't know that it would have a backlash. I mean, obviously, this was a scene where someone lost their life. So it's important that the jury actually see this information and see the penetration from the bullet and all the discussions regarding where the two gentlemen were standing in the street when it occurred, and whether or not it was a defensive wound or whether it was an aggressive wound. But I think it was necessary for the prosecution to show all of this evidence in order to get a conviction.
And Terry, the medical examiner said he edited his autopsy report after viewing the video. Do you think that's problematic for the prosecution?
It is a problem, Brian, for the prosecution, and that's why she attacked it head on. She was trying to say, look, he edited his report because he saw the video. And as Brian Buckmeyer said, the muzzle to target distance, it changed from 3 to 4 feet to 3 to 20 inches. That's a big difference, and it matters because of this, that self-defense claim. The closer it is, the more that they're going to be able to show that it was not that it was self-defense. The further away, it's going to be harder to show the self-defense. So it's an important issue, and that's why I think the prosecution was trying to make sure the jury knew that the medical examiner correctly edited the report.
And Brian, the prosecution has now rested. They rested on Tuesday. How does the case look for them, and what do we expect from the defense now?
So the prosecution's case led us through the whole event, first with the tragedy of seeing Ahmaud Arbery's body, some of the testimony from both Glenn County officers and GBI officers, and then ended with this drone video from Officer Dial of the GBI, really showing us the route that Ahmaud Arbery would have taken, along with that of William Bryant, based on the testimony. One of the bigger things that I saw from the medical examiner were the spurting of blood that we saw when Ahmaud Arbery and Travis McMichael are fighting with the gun, so we know that it was shot first and then struggle afterwards. Now they've rested, and it appears that it's up to the defense as to whether or not they're going to put on a case. I would guess, based on the opening statement, that Travis McMichael may end up testifying. All
right, well, that'll be fascinating. Thanks all. Coming up on Law and Crime Daily, a win for the families of the Sandy Hook school shooting victims. The latest in their defamation suit against far-right radio host Alex Jones. Plus, Steve Bannon turns himself in to the FBI before appearing in front of a federal judge. What's next for the former top Trump aide after the break? Welcome back to Law and Crime Daily. Former Trump aide and advisor Steve Bannon is set to be arraigned this week on charges of contempt of Congress in connection to the January 6th investigation. Bannon was indicted on Friday after he defied a subpoena to submit his records relating to the January 6th insurrection at the U.S. Capitol. He also ignored a call to appear in front of the so-called January 6th committee and testify about what he did that day and before. Bannon turned himself in to the FBI on Monday and briefly appeared before a federal judge. He faces 2 counts for refusing to testify or turn over documents, carrying a maximum penalty of 1 year in jail and up to $100,000 in fines for each count. All this comes as an appeals court temporarily sided with former President Trump, allowing his January 6th-related records to remain sealed for now. Oral arguments in that case are set for November 30th. Let's bring in Roger Foley and Terry Austin. Roger, Bannon claims he didn't turn over the documents because he was covered by executive privilege under former President Trump. But Bannon left the Trump administration in 2017, so how does something he did in 2020 or 2021 apply? How does that claim hold any water?
I don't think it holds any water. I think Steve Bannon is going to have some difficulty here. had this incident happened in 2016 or 2017 when he was part of the administration, then I think that he would have a valid argument. But considering this stuff happened January 6th, 2020, I think he's got big problems in regards to this. And I think ultimately he's going to have to turn over this information that they've requested of him.
And Terry, Mark Meadows, Trump's former chief of staff, also missed a deadline to answer questions. The Bannon indictment seems to send a pretty strong message to Mr. Meadows, doesn't it?
I think it does. And I think Mark Meadows has a reputation that he wants to defend. He really does not want to antagonize the committee. And we've seen that Bannon absolutely has antagonized that committee. And we know that Mark Meadows doesn't want to be held in contempt based on his actions. He seems as though he wants to have conversations. He wants to have a compromise. And I'm certain that he doesn't want to serve jail time. Now, we already know that they have signaled that they will be talking to each other. Mark Meadows really is in a better position because at the time, he actually was a part of the administration and he can claim the executive privilege or at least try to. So he has a little bit of leverage there. And I think because of that, the committee is going to negotiate with him in good faith, try to reach out a compromise, maybe produce some documents, and maybe even sit for a deposition. So Mark Meadows is going to try to work out all of these issues prior to being held in contempt or put in jail.
And Roger and Terry, Steve Bannon seems to be enjoying the attention.
I think he is, and I think he wants to make the point, as he said in his press clip, this is going to be the toughest misdemeanor. I'm not going to lay down. I'm going to fight the fight, and I'm going to have my day in court. And this is unprecedented, right? We've never had this in our nation's history. So it is an opportunity for him to speak his mind and say, because does Congress really have the power in regards to what they're asking him for? Because they're trying to say that he helped incite this. Whether or not that's true, we'll find out, but I'm looking forward to it, guys.
Absolutely. Okay, on to more federal news now, as potential jurors are screened in the trial of socialite Ghislaine Maxwell. She's accused of aiding Jeffrey Epstein in abusing underage girls. 59-year-old Maxwell is charged with 6 felonies, including conspiracy to entice minors to engage in illegal sex acts and transportation of a minor to engage in an illegal sex act. These charges stem from a relationship with longtime companion Epstein, who was arrested on federal charges of sex trafficking in 2019. Federal prosecutors say Maxwell helped Epstein groom girls as young as 14 years old for sexual abuse and sometimes participated herself in the abuse. Maxwell pleaded not guilty to all the charges and has been held without bond in a Brooklyn jail. This week, a federal judge will question potential jurors until 50 people are qualified. On the first day of trial, the jury will be whittled down to 12 jurors with 6 alternates. The trial is set to begin on November 29th. When we come back, controversial radio host Alex Jones found liable in the Sandy Hook defamation case. What's next for the InfoWars host and what this could mean for the families of the Sandy Hook school shooting victims. And welcome back. Turning now to a legal victory for the families of the Sandy Hook school shooting victims, as a judge finds controversial broadcast host Alex Jones liable in a defamation lawsuit. On Monday, Connecticut Superior Court judge cited Jones's non-compliance with the discovery process of the case, saying Jones was liable by default after he refused to hand over financial and analytical data at the request of the Sandy Hook families. The case stems from comments made by the InfoWars host calling the 2012 school shooting staged by actors. The Sandy Hook families maintain Jones has profited from conspiracy theories relating to the shooting. Jones has since acknowledged the shooting that killed 20 students and 6 staff members was not staged. From here, the case will now proceed to a jury to determine the amount of damages to be awarded to the families. A status conference in the case is set for Wednesday. Roger, there was a similar outcome for Jones in a Texas case, where he also failed to turn over documents. So now all that's left for the jury really is to determine how much money, right?
That's correct, Brian. It's just simply a trial on damages. how much damage has he inflicted on these families? How much pain has he caused? And how much money does he have to pay? That's what ultimately becomes the question. And the jury's going to come back with probably a big number because his statements, quite frankly, were outrageous. They're outrageous to anyone, even as probably his own fans. You know, to say that these killings were staged is just, there's no understanding of why someone would say something like that, and knowing the detrimental pain that it causes to a family.
And Terry, what does he have to, the plaintiffs have to show now in order to get damages from Jones? What do they have to make their case with?
Well, normally they would have to prove their case. And with a defamation case, you'd have to show a false statement, a publication of a false statement. You'd have to show that that statement was knowingly or negligently made. You'd have to show the harm. But here, because there's a default, as Roger just said, all they have to do is show the damages. And what they can do here is show if there was emotional distress, come in with a doctor's invoice showing exactly how much that was. Come in and show that there was lost wages because of the emotional strain and stress that it took on their lives. So they'd have to document the actual damages that they incurred, but they don't have to do anything else, Brian, because that's already been done with the default judgment.
All right, Terry Austin, Roger Foley, thank you very much. And thank you for joining us here on Law and Crime Daily. We'll see you next time as we discuss justice in America.